Ready, start. The petitioner retired from service as lecturer from a college on 36 2014 and he was allowed to continue till the end of session. Full stop. The contention of the petitioner's counsel is that after having joined in the institution consequent to the recommendation of the selection committee on 18/11/2002, the period of petitioner's service should be counted from that date in order to calculate the qualifying years of service for the purpose of calculation of pension, which requires completion of 10 years of service. Full stop. According to the petitioner, he had worked for 11 years, 7 months and 12 days. Full stop. He therefore, having completed the qualifying years of service, was entitled to post-retirement benefits. Full stop. It is also the admitted case of the petitioner that the approval to the appointment of the petitioner was delayed by the university and the vice chancellor passed the order on 12/1/2014. Full stop. It is urged that this approval should relate back to the date of appointment and even otherwise after the recommendation having sent to the vice chancellor, this appointment will be deemed to have been approved in terms of the provisions of section 31 within bracket second within bracket C of the State Universities Act, 1973. Full stop. Learned Counsel submits that the reference to the date of approval by the respondents is erroneous inasmuch as, the completion of the mandatory period of tenure was established on record with the joining of the petitioner in the year 2002 itself. Full stop. A counter affidavit has been filed on behalf of the respondents alleging therein that the petitioner had been approved on 13/1/2004 as a lecturer in the institution. Full stop. In such circumstances, keeping in view the relevant provisions of the Civil Services Regulations read with the provisions of Section 31 and the relevant government orders, the petitioner was not entitled to include the period of service prior to his approval. Full stop. Learned Counsel submits that any delay on the part of the respondents in extending the benefit of approval cannot take away the right of the petitioner as he has actually served in the institution. Full stop. We have considered aforesaid submissions and we find that there is no challenge raised by the petitioner to the date of grant of approval, which is 12/1/2004. Full stop. In the absence of any challenge having been raised to the said date of approval, it is not open to the petitioner to contend that his appointment will be deemed to have been approved from a prior date. Full stop. No challenge appears to have been raised to the delay in approval of the selections. Full stop. The petitioner has acquiesced to the said status of his service. Full stop. In the instant case, the approval has been given on 12/1/2004 and the same having not been challenged, the aforesaid action now cannot be questioned. Full stop. Consequently, the petitioner having completed 9 years and 6 months of service upon approval, the same falls short of the 10 years mandatory period. Full stop. Consequently, the relief as prayed for on the aforesaid strength cannot be granted as the petitioner had not completed 10 years of qualifying service. Full stop.